for the recording, we're on Chapter 6, starting at verse 39 in the PDF. If you have Adobe, actually indicates page 41. So anyway, it's Chapter 6, the use of a warrant in arrests. The requirement for warrants in the seizure of persons and property is an affirmation of common law principles. The declaration in our constitutions prescribing the mode in which they are to issue reflects the abhorrence of the use of the so-called general warrants, by which easy and arbitrary arrests and seizures were made. Despite such declarations for the security of liberty, privacy, and property, history shows that the executive department has strong tendencies to disregard and violate them, as revealed by the U.S. Supreme Court. Quote, though the police are honest, and their aims worthy, history shows they are not appropriate guardians of the privacy which the Fourth Amendment protects. Close quote. While the Fourth Amendment has been badly violated, we find that the due process of law provision is virtually ignored when it comes to warrants. For the most part, it is the due process provision which prescribes the actual requirement of a warrant for all arrests except where public security allows a warrantless arrest. Warrant to be in the possession of the arresting officer. A warrant of arrest is a written order issued by a court or magistrate directed to a peace officer or to a specified private person commanding him to arrest a named person. It is regarded as fundamental law that where one cannot arrest without a warrant must be acquired and be in the actual possession of the one making the arrest, otherwise he is not protected by it. The requirement of having the warrant for arrest in actual possession is the common law rule and thus is part of due process of law, and it is a procedure which deprives a citizen of his liberty. In a case where a policeman, by direction of a sheriff, arrested an individual pursuant to a warrant, it was claimed the arrest was unlawful since the sheriff retained the possession of the warrant in his office. The Supreme Court of North Carolina held that the overwhelming weight of authority for misdemeanor charges is that the officer must have the warrant in his possession. The court stated the following, quote, in 6 CJS, I guess that's Corpus Juris Secundum, arrest, that's in Section 4, page 576, et SEQ, I guess in following, we find the general rule stated as follows. The warrant must at the time of arrest be in the possession of and with the person purporting to act thereunder, or of one with whom he is acting in conjunction. Accordingly, where the warrant is at the officer's house some distance from the scene of the arrest, or in the hands of another who is not at the scene of arrest, or in the central office of the city detective bureau, the arrest is unlawful. Close quote. Since there was no felony or breach of peace committed in the presence of the policeman, his arrest was deemed illegal, despite the fact that was a valid warrant for the individual arrested, since it was with the sheriff who was in another town. The court also said that the good faith of the policeman did not affect the unlawfulness of the arrest. Obviously, that's carried over from the previous chapter. Good faith or probable cause has no bearing. A Mississippi case involved a warrant that was issued for the arrest of a Bill Smith on a reckless driving charge. Under the sheriff's instructions, a deputy went to Smith's home to arrest him while the warrant remained in the sheriff's office. Smith asked to see the warrant for his arrest. The deputy replied that he did not have it with him, but that it was at the sheriff's office and Smith could see it when they arrived there. However, Smith said he would have to see the warrant before he would submit to the arrest. Smith resisted the arrest. The sheriff was called out, but came without the warrant. Smith again resisted, but was forcibly taken to jail. The state Supreme Court held the arrest unlawful. Quote, under the great weight of authority, an officer making an arrest for a misdemeanor not committed in his presence must have the warrant for such arrest in his actual possession, if the arrest is to be lawful, close quote. In a criminal case involving a violation of a lien, a policeman was given a warrant for the arrest of a man named Shaw. He drove to Shaw's house in a buggy. He left the warrant in the buggy, being some 150 yards from the house. The officer went into the house and put his hands on Shaw's shoulder and told him that he had a warrant for him and to consider himself under arrest. Shaw asked, "What for?" The officer replied, "For disposing of property under lien," and that a Mr. Bradham had sworn out the warrant. Shaw said, "I am not going." He resisted the arrest and claimed at trial that the arrest was not valid, as at the time of arrest the officer had not actual possession of the warrant. The state Supreme Court held that the warrant was in fact in the officer's possession. Quote, "The authorities agree that in cases of misdemeanor not committed in his presence and for which he cannot lawfully arrest without a warrant, the officer should have the warrant in his actual possession at the time of making the arrest. It was not necessary that he should have the warrant in his hand or in his pocket at the time of making the arrest. Actual possession of it does not mean that the warrant that he can produce it with reasonable promptness on demand." Close quote. The question of what constitutes possession of the warrant has often been debated, of course, but it is obvious that it must be so close at hand as to show it upon request. Thus, it need not be said that the warrant must in all cases be directly in the hand of the arresting officer. This would be too narrow and technical view of the law, and one not based on substantial grounds. Oh boy. One reason for actual possession is to show the authority for the arrest. Another is to display or read the warrant. And since this is to be done promptly, the possession must exist. Thus, the warrant must be in possession, but not necessarily in hand, as the Federal Circuit Court of Appeals stated. Quote, "The officer who seeks to arrest by virtue of a warrant must have the warrant in his possession at the time of arrest." We need not undertake to define exactly what is meant by "in his possession." Of course, it does not necessarily mean that the warrant shall be actually in his hand, close quote. Where a warrant was directed to all police officers and exhibited to two officers but was kept in the police station, the warrant was not sufficiently in the possession of the two officers to sustain an arrest by them. In the rather famous and landmark case of Cross-White versus Barnes, a warrant for the arrest of a Mrs. Barnes was issued by a justice for a misdemeanor and placed in the hands of W.T. Cross-White, chief of police. Cross-White, along with a police sergeant, set out to execute the warrant, but left the warrant of arrest in his desk at the courthouse. When the officers first saw Mrs. Barnes, she was driving down State Street in her automobile. The police turned their car in front of Mrs. Barnes' car to stop her. One officer opened her car door, took hold of her by the arm, and said, "Get in my car." She refused and told the police she would not go anywhere without her husband. The policeman said, "We want you, not your husband." She asked the officers to show her the warrant. Mr. Cross-White said he did not have to do so, and said that you were going to the courthouse. The argument continued, ending in Mrs. Barnes being forcibly taken to the courthouse. Mrs. Barnes brought an action against Cross-White and the other policemen for illegal arrest and assault and battery. The police were found guilty, and on appeal, the Supreme Court of Appeals in Virginia affirmed the conviction, and a very authoritative decision stated, quote, "The textbooks generally state, and many cases hold, that it is necessary not only that a warrant of arrest should have been issued, but that the officer making the arrest shall have it with him and show it on request." In Beale's Criminal Pleading and Procedure, Section 18, it is said an officer arresting on a warrant must have the warrant with him and must show it on request. In Bishop, New Criminal Procedure, Section 190, it is said to justify an arrest under a warrant, the officer must have it in possession, and if though delivered to him, he leaves it at his office or station house, it will not protect him. In two ruling case law, 465, Section 2.3. Speaking of misdemeanors not committed in the presence of the officer, it is said the officer should have the warrant in his actual possession in order to justify the arrest, and if he does not have it, although it has been duly issued, an officer making arrest may not be protected by it. Close quote. The court also referred to and relied upon a previous case in Virginia, the case of Musco versus Commonwealth, in which a policeman undertook to arrest Musco for a past misdemeanor without a warrant, and Musco shot and killed him. He was convicted of murder, and in the appeal the court reversed the conviction, stating, indeed, not only must there be a warrant in the class of cases last mentioned, misdemeanors, but to justify the arrest, the officer must have the warrant with him at the time. Since a warrant must be in one's possession to arrest, the sheriff has no authority to send a deputy to one place to make an arrest without a warrant. While he goes to another for the same purpose with the warrant, nor can he send his deputy into one town while he gives pursuit in another. Just on a side note, what I was reading in this, I guess it's the law on sheriffs. It's called Anderson on sheriffs. It says that if a deputy is in breach of his authority, the sheriff is actually liable for the deputy's breach of delegated authority. That's something to keep in mind. Here's a court case. Quote, under the ancient practice of hue and cry, before warrants were issued, this might be done in the pursuit of felons, but no hue and cry could be raised for a misdemeanor. We think it clear that in cases of misdemeanors, the sheriff must be present either in sight or hearing, directing the arrest to justify a person not armed with the warrant to make the arrest, close quote. In a Georgia case, a warrant was issued for the arrest of Shaw, charging him with a misdemeanor. The warrant was directed to any sheriff, deputy, coroner, or constable of the state. When a constable tried to arrest Shaw at his home, a friend named Adams interposed and asked the constable if he had a warrant for Shaw. The officer replied that he had it at his home, but not with him. Adams thus prevented the arrest of Shaw and liberated him from the custody of the constable. Adams was charged with interfering with the arrest. The Supreme Court of Georgia held that Adams was not guilty of any offense since Shaw was not legally in the custody of the officer by virtue of a lawful arrest. The constable had no authority to arrest except under the warrant, which he did not have in his possession. The court held, quote, whenever a warrant has been issued to arrest a person charged with an offense in respect of which he cannot be apprehended without a warrant, the police officer must have the warrant in his possession at the time when he executes it. If he has not, the arrest will be illegal, close quote. Later, the court upheld this case under a similar situation where a warrant had actually been issued for an arrest, but the warrant was in the hands of the sheriff a number of miles away from where the arrest took place. The arrest was not lawful as the officer making the arrest had not been in possession of the warrant. In many cases, unlawful arrests have occurred where an officer received some sort of communication from another jurisdiction or a central office that a warrant exists for the arrest of a particular individual. The officer relying on such information and making an arrest upon it is liable for false imprisonment, as he arrested without a warrant in his possession. One treatise says, quote, in a case where the officer of one city, county, or district telephones to officers of another city, county, or district to make an arrest of a party with the last mentioned city, county, or district, it affords the officer attempting to carry out the instruction no protection, and the arrest is illegal unless such officer would have a right to arrest without a warrant, close quote. And that is from William H. Anderson, A Treatise on the Law of Sheriffs. Oh, look at that. That's pretty cool. Alrighty, to continue. I'm sorry, let me read the rest of that. His site was Walter H. Anderson, the Treatise on the Law of Sheriffs. It says a sheriff is liable if he arrests for a misdemeanor when acting upon a telegram stating a warrant exists. That gives a court case. Oh, this is good stuff. All right, to continue reading. Thus where an officer was informed by a letter written by the chief of police of a city in another state that a certain person has absconded with funds belonging to a benevolent association, the officer was liable in damages for the arrest of the person without a warrant. The fact that a person knows that a warrant for his arrest is outstanding does not eliminate the need for possession of the warrant in making the arrest. In Anderson's Treatise on Sheriffs, there you go. That's the one I'm sort of currently going through. It states, where arrest is being made under the authority of a warrant, the officer attempting to execute same and arrest a party named therein must be in possession of said warrant, or it affords him no protection. The necessity for the possession of the warrant is not relaxed by reason of the fact that the party to be arrested knows of the issuance and existing of such warrant for his arrest. Closed quote. Thus, where an arrest is made without having the warrant in the possession of the arresting officer, such an arrest is treated as though it were made without a warrant. So that is the first element of an unlawful warrant. Has to be in the possession of the one arresting. Cool. Next one. Warrant to be shown upon arrest. Coupled with the requirement to have the warrant in possession when making an arrest is the requirement to show or display the warrant to the arrested person. Where an arrest is claimed to be made under the authority of a warrant, it is the duty of the one making the arrest to show the warrant and read it to the one being arrested, especially when he requires to see it or demands to know the nature and cause of the arrest. He need not submit if this is not done. In the case of Smith versus State, Supra, the Supreme Court of Mississippi not only said that the warrant must be in the actual possession of the officer, but he must show it to the accused if requested to do so. In State versus Shaw, Supra, the court said that the reason that a warrant is to be in the actual possession of the arresting officer is that if demanded, he must produce the warrant and read it to the accused, that he may know by what authority and for what cause he is deprived of his liberty. In Cross-White versus Barnes, Supra, it was stated that the arresting officer must have the warrant with him and must show it on request. It cited a number of authorities in support of this, such as the following. In the annotator's summary of a note in 42 LRA, I don't know what that is, at page 682, it is said, an accused person, if he demands it, is entitled to have the warrant for his arrest shown to him at the time of arrest. This happened when probably last year, or a little bit longer than last year, when a constable here in Pennsylvania, constables are usually hired by the courts to go out and apprehend people who don't show up for their court hearings. So apparently there was a warrant out for my arrest, and this constable contacted me by text. And then, to make a long story short, I contacted him by email. And we had this email correspondence for a little bit, and I asked him for him to send me a copy of the warrant so I could see if it was lawful or not. Lo and behold, though, he did nothing of the sort. But it was kind of an interesting thing going through that experience. And then not too long after that, he just didn't contact me anymore, and he had just empty threats about picking me up and bringing me to jail or before the magistrate. Anyway, back to the treatise. In an early case in New York, a special deputy was charged with the duty to serve a warrant for larceny issued by a justice of the peace. The person arrested had required the deputy to show him the warrant before he would submit to the arrest. The deputy did not do so, and the man resisted, and the deputy beat him. At trial, the judge charged the jury that if the defendant did not show the warrant to the man, he was a trespasser. Nice. The jury found a verdict in favor of the man arrested. The Supreme Court of New York upheld the verdict, stating, A special deputy is bound to show his warrant if requested to do so, and if he omit, the party against whom the warrant is may resist an arrest, and the warrant under such circumstances is no protection against an action for an assault, battery, and false imprisonment. Failure to show or display a warrant when a warrant for an arrest allegedly exists, the arrest becomes illegal. On this matter, the Supreme Court of Georgia stated, in Galliard v. Laxton, it was held that in a case in which a lawful arrest could not be made except under a warrant, the arresting officers were bound to have the warrant ready to be produced if required. That an arrest in such a case by police officers who did not have the warrant in their possession at the time was illegal. Close quote. Thus, the primary reason for the officer to have the warrant in his possession when making an arrest under the warrant is so that it can be shown to the one arrested, so that he knows the authority by which he is being deprived of his liberty. This was so held by the Supreme Court of Texas. Quote, it ought not to be denied that the law contemplates that the warrant directing the arrest of a person charged with a crime will be in the possession of the officer when he makes an arrest under it, for he is required to exhibit it if called upon to do so. And this is based on a wise public policy, one purpose of which is that the officer may have to exhibit such evidence of his authority to make the arrest as will be deemed sufficient to take from the person whose arrest is commanded all right to question the authority of the officer. Close quote. The argument that officers are free to arrest because there is a warrant outstanding is nullified by the requirement of law that one arresting under a warrant must show it if requested to do so, which is manifestly impossible unless he has the warrant in his possession. An officer arresting for taxes due on a tax warrant was held to be a trespasser, where he had not the warrant with him at the time of arrest, thus failing to show it to the one arrested. The court unanimously held, quote, we think the authorities are all to the effect that the officer making the arrest must be in a situation to show, if required, the authority under which he is acting. It is the legal right of the citizen when arrested that such shall be the situation, and therefore when such situation does not exist, the arrest is a legal wrong. Close quote. It's interesting, side note, it's interesting that I've noticed this 2 or 3 times. I think it was in this section that when an officer tries to arrest without a lawful warrant, he's named to be a trespasser. Kind of interesting. All right, to continue on. An arrest warrant is to be shown to the accused, for he has a right to see if it is a valid warrant. Speaking on the topic, production of warrant, one law textbook states, quote, every person relying upon a warrant in making an arrest should read it if requested so to do. Where warrant is necessary, but the person making the arrest refuses to exhibit it when called upon to do so, he may forfeit the protection which it otherwise would afford him. Close quote. In the Annotation of American Law Reports, Volume 40, page 62, a review was given on the topic, necessity of showing warrant upon making arrest under warrant. The report clearly showed many other cases that held that the officer must show the warrant upon request and stated, quote, the weight of authority now, however, seems to support the proposition that an officer making an arrest under a warrant should show the warrant, if requested to do so. And in some jurisdictions, he is expressly required by statute to do so, close quote. The enactment of a statute that the warrant is to be shown upon arrest is but declaratory of the due process procedure that must follow in an arrest. Thus, no statute is needed, and where it exists, it is merely redundant in nature. So the statute has no bearing on the warrant, the unlawful warrant. That's an interesting point. The annotated report did speak of some authorities where it appeared that the failure of showing the warrant was allowed. It stated in the review that in some cases, a regular officer does not need to show his warrant before making an arrest thereunder. Such cases involve the question of whether the officer is known or unknown to the person being arrested. In some cases, it was stated that when the officer is known, he need not show the warrant before the arrest, but must show it after the arrest. And where the officer is unknown, he is to show the warrant before the arrest. Other cases where it appeared that the showing of the warrant was not needed is where resistance is offered or threatened before the person asks to see the warrant. The argument that a known officer need not display his warrant at all, or that in lieu of displaying it need only state the authority on which he is acting, is not justified by the principles for why warrants are needed in the first place. Such an argument can completely take away most of the safeguards of liberty which the requirement for a warrant was established. The true law on the matter requires the officer to possess and display the warrant, whether he is known or not, in addition to his stating the nature and cause for the arrest. The generally recognized rule, however, sustained by the weight of authority, in particular in cases of misdemeanors, requires the officer to exhibit the warrant of arrest before the arrest is made unless there is some resistance. In an English case cited in 40 ALR, annotated, it was held that where a constable making an arrest did not have the warrant with him, he was not justified in making the arrest. The court said, quote, "We have already expressed our opinion that if requested, the officers are bound to produce the warrant, and if so, the keeping in custody after request and non-compliance would not be legal, and it could hardly be contended that the arrest itself could be legal." Close quote. In an older English case, it was said that the doctrine that an officer need not show his warrant was a dangerous doctrine. The court also stated, quote, "I don't think that a person is to take it for granted that another who says he has a warrant against them without producing it speaks truth. It is very important that in all cases where an arrest is made by virtue of a warrant, the warrant, if demanded, at least should be produced." Close quote. The reason for the duty of an officer arresting a party by virtue of a warrant was declared in Comm v. Cooley, 1856 case, as being to explain the cause for which he makes the arrest, to state the nature and substance of the process which gives him the authority which he professes to exercise, and if it is demanded of him to produce and exhibit it to his prisoner for his perusal, that he may have no excuse for resistance. The court added that these are obviously successive steps which cannot all occur at the same instance of time. In a New York case, a man was convicted for resisting a police officer who attempted to arrest him for a past misdemeanor, the warrant being at his office. His conviction was reversed because it was the duty of the officer at the time of the arrest to disclose to the defendant his authority and the process under which he was to be arrested. The court said the state statute was the same as the common law doctrine on this matter. Quote, "If the officer must show the warrant, if required, then it is plain that it must be in his actual possession. It would be absurd to construe this to mean that after making the arrest, the officer must, if required, take the defendant to some other place and there show him the warrant." Close quote. It is clear that the warrant must at the time of arrest be shown, not at a later time. In State v. Finney, it's an 1856 case, the court, in discussing authority, stated that it is very important in all cases where an arrest has been made by virtue of a warrant that the warrant should be produced if demanded. In Chauvelin v. Comm, 106 PA 3695 AM Criminal REP 41 year 1884. Sorry about all that. The court, in explaining the duty of one making an arrest, said, quote, "It is doubtless the duty of an officer who executes a warrant of arrest to state the nature and substance of the process which gives him the authority he professes to exercise, and if it is demanded, to exhibit his warrant, that the party arrested may have no excuse for resistance." Another state Supreme Court case held that a constable was not justified in attempting to arrest the defendant under a warrant which was in the sheriff's hands. The court said that it was the duty of an officer who attempts to make an arrest to exhibit the warrant if he has one. Okay, so he has to have the warrant in his possession and he has to show it upon request. Those are 2 points of a lawful warrant. Here's the third point. I think we'll go through this, and I think that'll end this chapter. Invalid and unlawful warrants. A warrant must have certain requisites in order to render it valid and available as a defense. Many unlawful arrests have been made due to warrants failing to meet such requisites. Whenever a warrant is invalid on its face, or where it is only a summons, the officer arresting the defendants will be liable in damages. A prima facie invalid warrant will be regarded as no warrant, and the officer making an arrest by a void or invalid warrant is not protected by it. Process that is void on its face is no protection to the officer who executes it. If a warrant, order, or writ of possession shows lack of jurisdiction of the court, the officer is not protected in serving it. In fact, in so doing, he becomes a trespasser. There's that word again. A constable justifying an imprisonment under a warrant must show that the warrant on its face is legal and that the magistrate had jurisdiction of the subject matter. Both a proper subject matter jurisdiction and geographical jurisdiction are necessary for a valid warrant. It is generally held that where the court has no jurisdiction, the officer executing a warrant will be liable in damages. The question of jurisdiction can be raised at any time, and since neither consent nor waiver can give jurisdiction, the court will not proceed where it appears from the record that it has no authority. A warrant for the arrest of an alleged fugitive was void because the complaint did not state that the original charge has been made upon oath or made to a court, and it afforded no protection to the constable. The requirements of what a warrant should contain depends primarily on constitutional mandates and common law principles. Common law requires that an arrest be made on a warrant be issued only after a formal charge is made under oath. Thus, no arrest is valid unless based upon a sworn affidavit. So there's a third point for a lawful warrant. An affidavit that does not appear to have been sworn before any judicial officer, and a warrant signed only by the officer who made the arrest and not dated or authenticated, afford no lawful authority for the arrest and detention of an accused. Maria, are you still on the call here? She might be outside helping Bill. Okay, continue on. Another obvious requirement of a warrant that would make it void on its face is if it is not signed by a magistrate or justice of the peace. It has become a practice in some areas to have warrants rubber stamped with the judge's name. This stamping being done by some clerk or administrative employee. This blatantly unlawful practice has been adopted for convenience sake, which is the most common reason or excuse government uses to transcend constitutional limitations. Such limitations were designed to make government follow certain established procedures and thus make things difficult in order to deprive a citizen of his liberty or property. A rubber-stamped warrant is invalid on its face as it is not signed by any judicial officer. The authorization for a warrant requires not only judicial authority, but is to be done by one who is learned in the law to determine if probable cause exists to issue the warrant. In Minnesota, the state Supreme Court held that a statute permitting clerks and deputy clerks of the county municipal court to receive complaints and issue warrants in prosecutions under municipal ordinances is unconstitutional. The court said, quote, "The United States Supreme Court has considered and disposed of a related problem in Camara versus Municipal Court. The majority in Camara nevertheless stressed the need for individualized review by a neutral magistrate to avoid the issuance of rubber-stamp warrants." Close quote. Since the taking of an affidavit in a criminal proceeding imposes a duty of a judicial nature, an affidavit taken before a clerk or prosecuting attorney is not sufficient as basis for the issuance of a warrant. Oh, that's interesting. That's a good point. A warrant is regarded as insufficient and thus void if on its face it fails to state facts sufficient to constitute a crime. Also, a designation or description of the offense should be written in the warrant, but need not be specified with the same technical strictness that is required in an indictment. The rule on sufficiency of a charge on which a warrant can issue is stated as follows, quote, The complaint or charge on which a warrant is issued must set forth the facts constituting the offense on the knowledge of the person making the complaint. And if he does not know them, other witnesses must be examined who do know them. And no person can be arrested on the mere belief of the person making the complaint. Close quote. A warrant issued for a matter that is not a criminal offense is no justification for a constable who arrests upon it. A person cannot be lawfully arrested by a sheriff acting under a copy of a court order or warrant in the form required. Such copy is not valid. Inaccuracies and imperfection do not vitiate a warrant which substantially charges an offense. But where a complaint recited in substance in a warrant is verified merely on information and belief and does not state facts sufficient to constitute an offense, the warrant must be held to be invalid on its face. Also, an affidavit that merely states belief in the guilt of the accused is insufficient to support a warrant of arrest. The Supreme Court of Kansas said that a warrant cannot be issued which is verified on the county attorney's hearsay and belief. Quote, if a warrant in the first instance may issue upon mere hearsay or belief, then all the guards of the common law and of the Bill of Rights to protect the liberty and property of the citizen against arbitrary power are swept away, close quote. An affidavit based upon a presumption or belief of crime does not give jurisdiction to the court to issue a warrant. And at common law, a constable or sheriff cannot execute a warrant outside their jurisdiction. To summarize, the following are the basic requisites needed to make a warrant valid. A warrant is to be issued by a judicial officer and signed by him. It must state the facts that show the matter to be within the jurisdiction of the judicial officer issuing it. It cannot be based upon belief or suspicion, but upon probable cause. The warrant is to list a complaint, which is to state the offense committed and the facts that constitute a crime. A warrant is to contain an affidavit of the person making the charge under oath. It must truly name the person to be arrested or describe him sufficiently to identify him. The officer is bound to know if under the law the warrant is defective and not fair on its face, and he is liable as a trespasser. If it does not appear on its face to be a lawful warrant, his ignorance is no excuse. Every citizen should, when arrested or at trial, request to see a warrant and check that it meets required criteria and object if it does not. Such vigilance is necessary to secure liberty and to stop unlawful and oppressive measures from continuing in government. That concludes Chapter 6. So we'll just end the study here and pick it up again next week. Maria, are you back on the call?
Yeah, hi. Did you have a question about the lawfulness of that warrant?
Yeah, I was going to ask you about Chris's warrant. That was basically, was it just signed by the state trooper, or was it signed by the judge as well?
Yeah, there was a magistrate judge who did sign it, and
now, did he actually sign it, or was it rubber stamped?
I think, if I'm remembering the right one, I think he did sign it. But
I got to go, Peter. Get on another call, so I'm sorry I got to leave. I'm sorry to interrupt you.
No, it's okay. Thanks for joining.
Talk to you later.
Yeah, we'll talk to you soon.
Okay, bye.
Okay, take care.
Yeah.
Boy, Marie, it's slim pickings tonight.
Yeah. Well, everybody should be here. This is great. It's just amazingly good. Just that treatise is so awesome. So, but we'll get it put out, shared out, because people have asked for it. That the warrant, there was no complainant. It was a hearsay affidavit, and it said on the affidavit it was an affidavit in support of a complaint. It's supposed to support the complaint to be done at all, but there has to be a complaint before the magistrate for the warrant to be valid. But the reason they do this is because no one knows how to challenge it.
Oh, yeah, right.
So, yeah, so we have to learn the law and then challenge just the simple parts of the process, and that's what Chris is doing. He's going to take, he's going to put this in a court of record in the District Court of the United States, I believe is the right title that goes on the paper. And I don't know if you listened to Alphonse Fagioli in the number 113 on Crow.
I think the link that you sent I listened to. I don't remember all of it.
Well, there were three. He did 3 shows so far, I think, 3 or 4. But I went through and I listened last night to the first one he ever did. And I remember having heard it originally at the time it was published, and I thought it was fantastic. But he writes that the way he does his special appearance, it's super, super clean and simple on this number 113 about challenging the jurisdiction of the court and how you characterize who you are. And he says, I'm here by special appearance, being here by special appearance, and this is on the paper before anything happens, any hearings happen. And he says, by special appearance in this court of record. And then he swears, makes his sworn statements of truth, and he calls them affidavits. And he gives you the elements of these affidavits. So anyway, this is the way to put this claim, I believe, into the proper court of record in the District Court of the United States, is to do it on paper.
And he's what? Is he being the complainant or the respondent?
He's being the claimant. Yeah, the claimant.
Okay.
Yeah, in court of record, the man is the claimant. He makes a claim. And so, yeah, it's, and if you listen to George Gordon, it talks about at the scene of the crime, you need to make sure you have certain reversible federal questions that you raise. And so the one reversible federal question Chris did raise was he required the warrant many, many times.
Yeah.
He didn't require to be taken before a magistrate. He didn't require to have counsel present. He may or may not have invoked his right to remain silent. But when you are responsible, when you're a responsible citizen or arrestee, you would do all these things, because then you have all the basis. You've given them a fair chance to remember what the law is and to act under it. And if they don't, you have created the record that, that these are reversible federal questions. So Chris demanded the warrant, and they refused to give it. So there you go. It's a false arrest on its face.
Strike one, 2, 3.
Yeah. And number 2, that's strike 1. Strike number 2 is that the warrant, the toilet paper, thin warrant, which that is also unlawful, says to take him to the nearest judicial officer. And that didn't happen. They took him to a false imprisonment.
Yep.
So then you look at the basis of the warrant, and there's no complaint. There's only a hearsay in support of said missing complaint.
Now, do you have a copy of that warrant?
I think so. I'll look it up in Chris's file. I probably do. I probably threw it into a file somewhere. But yeah, it says. Sure. Now, here's one more thing about this. The attorney, did I tell you this? The attorney for for his estranged wife, advised her not to swear out a complaint and pursue a writ of assistance because she already had a judgment in her favor. However, this judgment was made void by Chris because it was devoid of due process, and it was an unlawful, it was a void judgment.
Right.
And it meets the criteria. So underneath all of this is a statute, supposed statute violation based on a phony court order, based on a sham proceeding, based on,
it's got fraud written all over it.
I mean, it's just so deep. And what they hope to do, now what they've done, is married all the cases together so that it's just confusion magic all over the place. So it's important to now recall each issue dispassionately, which I'm able to do because I've heard about it every step of the way, and then start to separate these various reversible questions and what do we call pinnacles of law, separate them out so that you can have a chance of having each one individually redressed. So, that's kind of the question. What's the best way to go forward and do this? And it seems to me the best way is to take each separate event that has happened over this time and do a separate affidavit on each event and show each unlawful act done by, agents of the corporation or agents of the agencies, however you want to look at it. But yeah, so.
What stage is Chris at right now?
What stage?
Yeah.
The last thing I saw, I think he's just working through writing up the affidavits and getting all of the elements of an affidavit firmly in mind so that each one has got all the characteristics it has to have to be to be recognized by the court.
Yeah.
Now, Alphonse does a really good thing, and I think I probably would have gone in the exact direction he's gone in if I hadn't run into Carl Lentz. And that is just simply, one of the people of the several states, not I-man, I wouldn't have gone that far. I would have just gone to the, how to identify. I'm one of the people of the several states, and I'm here by special appearance. I waive none of my rights, to get that in, reserve all my rights, waiving none ever. I'm here in this court of record, and I declare such and such. Because special appearance doesn't give that jurisdiction. It's not giving jurisdiction to the court. Actually, it's not giving jurisdiction to the court. You're there by special appearance to help clear up the matter. You're in the court of record, and you're going to say, look, first thing to do is always challenge jurisdiction. The state, the way he words it is the state of blank grossly exceeded its jurisdiction. And you don't have to show, that's another one where the burden of proof now is flipped to them. They have the burden of proof to show that they have jurisdiction. And then in this criminal sham, so you haven't allowed, let me go back. They have the burden of proof. You haven't allowed the Nitze Prius court to move forward. can roll over you. So that's like step numero uno, step one. Get the affidavit in to that effect, and then any other issues can come later by way of affidavit.
Do you have those shows from?
Yeah, I do. Yeah.
You have all four?
I'll go back through. I think it's either 3 or 4, but I have everything. I think I downloaded everything he's done, and even just hearing the first hour is just unbelievable. But the second hour, it adds a little bit. It adds a little, and you can. I think he's really good to write to you. He swore that he would help everybody. He swore to God that he would help everybody who asked him. And,
Did you reach out to him?
Did I?
Yeah.
No. I haven't. Maybe we should, but I feel like he's given us enough instruction that we just go forward with it. We have plenty of what you would call opportunities.
Sure. Yeah. Are you guys home now?
Yeah, we got that. We got the truck pulled out.
Yeah.
How much snow did you get?
Oh, we got it was
4 or 5 inches right now.
Yeah, 4
coming down.
Oh, that's nothing for you guys.
Yeah, well, we've been spoiled a little bit this winter because we haven't had a lot. But I mean, it started like at 9 this morning, and it didn't look like it was getting that deep. But man.
Yeah, but once you slip off just into the ditch where you've been pushing it all winter.
It's deep.
Yeah. Kind of a problem. So can I get the recording of this one?
We're getting all the recording.
Oh, okay.
I haven't done anything with them yet, though, but have faith I will.
Okay.
You mean the recording from this study?
Yeah.
Yeah. Well.
Missed it.
Yeah. We got to get them all.
We'll get there.
Yeah.
You'll get there.
Get them all. Yeah. It's really, really good. But I mean, of course, we have the treatise, and we can read that to each other, and just keep reviewing it. But if I was talking to my son today, and he really needs to learn this. He's got a friend that was in a situation, and I hadn't realized it, but it was 2 weeks ago, and he was placed under one of those kinds of SWAT team style arrests.
When did that take place?
About 2 weeks ago.
Well, with the heightened COVID nonsense, and they're just trying to give the psychological impression that they're just, if you don't do what we say, this is going to happen to you, to get everybody to comply. But why was he arrested?
Well, it's kind of it was like on a family issue where his wife called the police on them. You know how those ones go?
Yeah, domestic ridiculousness, yeah.
And then they imprisoned him. It was a false imprisonment in a hospital.
They imprisoned him in a hospital?
Yeah. In fact, we have heard that before. It wasn't. There's no criminal thing going on at all. So they use, and we had a friend up here too. He took his wife to the hospital, and it was more of a family kind of a meltdown kind of a thing. And they put her up into the mental ward for a certain period of time, and that's a false imprisonment.
Yep.
The KGB.
Yeah. This is.
East Germany.
East Germany, he said.
Nazi America.
I don't know the particulars of the history, but you can see it is. It's just an extremely dangerous time if you don't. And this is what he said. He said, well, you can study the law, but it doesn't make any difference because these people will shoot you in the head. Well, it's been, a long time that we haven't asserted any of this, and we haven't properly pushed back on these trespasses onto our liberty, onto our freedom, onto our rights, and we can't effectively and properly push back if we don't know the law. So, so it's so important. And but it seems to me that there's been a lot of people doing a lot of excellent work to make it doable and simple. You can do it yourself, So, but I'll send you that. I'll send you those episode numbers, and if I can get them attached to an email, I can send you the whole thing. But at least you'll know how to go in and get the first hour.
Let me ask you a question about Mr. Fagioli.
Yeah.
Whatever his last name is. What's his spiritual foundation?
It's proximate. I would say proximate. In other words, how many people are in the culture. They just have a kind of a belief system, but they really aren't in touch with the Gospels and the
there's a reference. There's an ambiguous reference to a God, a supreme authority, but there's no definitive expression of the reliance on, as we know, Jesus from the Scriptures. That's huge. Yeah. I mean, to me, it's huge.
Yeah. Well, it is, but and that's because you've been there for so long, but I don't know. I always just listen to somebody, I hear them out, and then I decide, what part of it I can take. I mean, lately I've been a little bit disgusted by some people that I thought were really good, and they're starting to go back to Hebrew roots, and I'm afraid that they're going back to the old law, and I think they're discounting the New Testament completely, and it's just too bad.
Yeah, well, that was why, when I gave the teaching on the juxtaposition of the Torah and Christ's law and the doing away of the Torah, and the focus is now on Christ's law, which is the higher law, the better law. That's being ignored and put to the side. So it really doesn't matter, all this liberty stuff. I'm just a broken record.
Well, ultimately you are right. Ultimately you're right. But also we have to meet people where they live, I'm not going to get anywhere with my son talking about the gospel. But talking about freedom and how the law is supposed to be, that's the beginning, because now he's beginning to wake up and see the system he's a part of, or maybe he's beginning to wake up. It's just really figuring out where other people are and seeing if you can slowly, if you can bring them along. And maybe I'm wrong. Maybe you never get there, but.
Well, it's a very fine line, and one we have to be led by the Holy Spirit to do. It's very difficult because in my experience, you could share liberty and law with people, but if we do it at the neglect of the author, then we're really doing a disservice. But I say that as a general statement because when you're actually talking to someone, it's a very difficult thing to try to, let alone try to explain lawful issues to them so they understand it, and then link it that it's inextricably linked and is a production of the gospel. That's a whole different thing. So it doesn't help that the church is ignorant and doesn't care. There's very few people who care about that, but nonetheless, right. When Jesus came, he came to be among the people, but he never compromised on the truth and what true law is, right. and he was often rejected and cast out or hated because of that. But nonetheless, we should follow in his footsteps, and if we're given the opportunity, just speak it, because that's the bottom line. I mean, people are just lost sinners, and they need salvation. That's where it starts. I mean, to me, it's pointless if someone is living life of liberty in this country particularly, but they're still lost. Doesn't mean anything. And
so certain people are hurting because their kids are being taken through OCS, and I understand the difference between somebody who is, strung out druggie, where, they are being irresponsible and they are going to make themselves an easy target, compared to a very good, very wonderful family that just happens to be on the conservative side, that is being targeted by a social justice warrior because they don't like white men, they don't like Christians, they don't like, whatever it is they're going after these people for.
Yeah.
I can make the distinction, and it's horrifying the kinds of families that this department is getting into up here and probably all over the country. So these people are hurting for this. You help them. And to me, I don't know, I just believe in helping people where they're at. And then by the same token, with Alphonse, if he has good information that can help us to uphold the law and win, I don't think it's wrong to incorporate what he's doing that's working into what we're doing, because we're ultimately working to uphold the common law, which to me is the gospel. It's freedom through Christianity, through Christ's law. In a way, it's a freedom that was never known or never talked about or never really followed until Jesus came. So all things work together for good, and the rest of that too. So now, if I were to say, well, Alphonse, not a professing Christian, can't trust anything he says, therefore I'm not going to use, I'm not going to listen to stuff that's working. I don't know about that. Although, he did say he said he was not religious in this number 113 on Crow. He says he was farthest thing from a religious person you could ever get. But it kind of reminded me of what Wendell said, that Jesus came to abolish religion, and that Christianity isn't what he would consider religion. So what Alphonse said was something, on one hand he said, I'm the furthest from a religious person you could get. The only time I go to church is on Christmas and Easter or whatever, Christmas, weddings and funerals. And then on the other hand, he seemed to understand where that the common law is the outworking of Scripture, and that's what we're supposed to be following. And he seemed to know who it was that he was supposed to be following. So you just have to make your own, you have to decide, make your own judgment call on whether or not you can trust him, I guess. maybe, Peter, maybe he's waiting for you because you've got the information and the knowledge he doesn't have.
Well, I just asked about someone's spiritual foundation just to see where they're at. I think everybody, whether you're saved or lost, if you're speaking truth, it's truth. If you're speaking law, it's law. It's irrelevant whether someone's saved or not. If the process is according to the truth, then yeah, that's cool. And like Carl Lentz, I will listen to him. Now I'm not going to say whether he's saved or not. I don't know that, but just from hearing him talk, it's like something's off here. And you hear someone's theology, and it's like it's not lining up with what the scriptures say. Anyway, it's not a judgment. Yeah. It's basically, just the antennas go up and say, that's not correct according to the scriptures. So, but like for example, for me, and we've talked about this, and I've talked about it several times here and there, and I hear it a lot, and it's the issue of the affidavit. Now, for me personally, I have a problem with it. And it's just me. I'm not saying that if someone else does an affidavit that that's a sign that they're lost and they're not going to heaven and they don't have the truth. That's not, it's not what I'm saying at all. I'm just saying for me personally, at this point, from what I understand scripturally, like I can't do the affidavit. I can't do it.
Oh, okay. All right.
So because it goes back to exactly what I'm talking about. Well, Jesus says not to swear and make oaths. But here an affidavit is swearing and making oaths. So I'm faced with the decision, okay, all right, this is how I'm understanding it. Well, according to how I'm understanding what Jesus is saying, I can't do an affidavit because it has to be sworn under oath. I can't swear. Maybe I'm missing an understanding there, but what I'm saying is that's where I'm at right now because I'm faced with the decision of saying, am I going to obey my Lord and Savior that I profess to believe in, or am I going to believe in some lawful process that's being propagated by people who follow that type of system? The point I'm at now, I can't do the affidavit.
Well, Bill's got something for you on that.
I've been kind of thinking that maybe we should be saying something like, this is the truth as I know it, and I put it here on the record under penalties of perjury.
Right. That's like a declaration. Yeah. And
right.
And I've shared this before, and you guys are probably well aware of it. So it's not like I'm probably saying anything that you don't know. But when I looked in Black's Law Dictionary and I compared the definition of affidavit and declaration, they're basically the same thing, except one you're swearing under an oath and the other you're not. So what I would, at this point, I would just make a declaration just as what you said, Bill, under penalty of perjury. But there's no way I'm going to, at this point, swear to anything because I'm commanded by my Lord not to, so I can't do that. See, this is the crux of it, isn't it? This is the outward expression of our faith in these very situations because there's, I don't know, it's like maybe it's a little lesson here, is that when we're saved, we're sanctified. And that means that we're different. We're supposed to be different than the world, the way the world does things, as our minds are being transformed, as it says in Romans chapter 12, verse 2, not to be conformed by the world, but be transformed by a renewing of our minds. So now we're faced with things to try to figure out how to do that the world doesn't. And that's a challenge because there's so much against us in a sense. If we just look at it in a physical sense, there's so much against us that to live differently the way we try to live, it's bizarre to the person who just doesn't have any clue. And that's across the board in everything, and how we live or should. That should be one of the things we strive for. Hey, like my business. Well, when someone starts a business, what's the first thing they usually do? Get a license or get incorporated. Well, as a believer, if I understand that my Creator's already given me the permission, I don't need another man's permission. I'm not going to get incorporated. So you think to yourself, even in that dynamic, how can you even function in, function living in a system that goes against all that? And that's where faith comes in. And this is the essence of what, I believe the Gospels are teaching us. The kingdom principles. Hey, and to stand for testimony. If anyone was to tell me you need to get a license, well, most likely I'm going to tell them my Creator's already given me permission. I don't need permission from another man to do what He's already given me the freedom to do. Actually, I've done that a few times. And there's no comeback to that, because what is someone going to say? There's no comeback, and it's like the law. There's no law that says I have to incorporate. So, anyway, that's the way. Now, and you guys heard me say this before. If we profess to be believers in the Jewish Messiah, we do not have a choice. Now, that sounds like restricting and controlling. But yeah, sure. It's a great way to be restricted and controlled. But really, it's not really our will to be done. It's really His will to be done. And see when we're talking about a thing of law, now it's going back to the gospel, right? But that is the law. Not our will be done, but His will be done. That's the law. So if people are professing to believe Him, sorry, you cannot go by the world's law, the way they do law, and reject Christ's law. You can't do it.
Well, okay, so look at Alphonse, this whole Alphonse thing. He is a little bit muddled, because he's claiming to be in a court of record, but he's writing an affidavit. In a court of record, you should have a declaration, and Carl Lentz showed how to do it. As man, I say herein shall verify in open court that all herein be true. So it's a verified claim.
Yeah,
which
right.
is much the way I thought he explained it was more it was like levels of magnitude above an affidavit, because that's a mere person.
Yeah.
So I'm not saying take everything Alphonse says wholesale,
right.
and just
put
across. It still has to be. So it would be good for him to understand the difference between a declaration and an affidavit, and that,
See, but like Carl Lentz, what he's saying is biblical. He may not even realize it, because after Jesus gives the commandment not to swear by anything, not the temple, not heaven, not earth, not anything, but let your yes be yes and your no be no.
Right.
That's, under the pains of penalty of perjury, and what you just said there, I'll verify everything is true. So that is God, that is Christ's law, and but the challenge is holding it up as Christ's law, not just it's a principle based on Christ's law, but it is His law. That's the difference. I think that the church, or even believers that are involved in this type of dealing with the type of things we deal with, need to get more confidence and boldness to stand on that, to actually say this is Christ's law. Your law is inferior or even null and void. That's huge.
It is. Well, that's exactly why I was so excited to get Brent Winter's book, because it proves, it absolutely over and over in 900 pages proves over and over and over where we get this stuff.
Yeah.
So,
and to be able to stand on it. Not just to refer to it, it's in there somewhere. No, we are called to know it and stand on it. Like if you're in a court and they want you to swear or make an oath, like for me, I'll tell the black-robed imposter, I can't do that because my God says I'm not allowed to. It's His commandment.
Yeah.
You know? So that's a witness to and glory to our Creator. You know, it's not like, you know, it has to be a major thing, but that's really the issue. It's the authority.
Katie was a witness in my trial over being arrested, and she did that.
I'm sorry, what was that?
I said that Katie was a witness in my trial in 2017, and she did that. She said my yes is yes and my no is no, and that's how she did her. You know, she basically negotiated with the magistrate and said, no, I'm not going to swear, but I'll say my yes is yes and my no is no, and they had no problem with that.
Yeah.
So it was good. We have actually employed what we're believing. So it's
I mean, it's a process. It's not, and I don't say these things to say, well, if you don't do it exactly the way I think that you should do it, that you're doing it wrong. Then you're that's not what it's about. But it's all this stuff really. It doesn't emanate with us. It should be an outpouring of a relationship with Him. You know, we get our boldness, we get our confidence, we even get our words, hopefully, in response to these people from Him. And that's how intricate our relationship should be with Him. And we're even depending on Him for the very words to speak to these people. You know, because it's our nature to try to want to cover every avenue, to try to, you know, figure everything out so we have all our bases covered. But as you probably well know as well as I do, that, you know, we get put in situations where that's not it. You know, we're put in situations where, you know, the Holy Spirit's going to see if we're going to be relying on Him even to speak the words He wants us to speak. That's a whole different level of living faith out, I believe. Like, I remember a while ago, you know, because we always deal with conflicts with one another, right, to some degree. I mean, there are times where we offend one another and may not even realize it, or there may be something that I'm doing that is irritating you, but I'm not aware of it. So, and some people will just blurt out whatever they want to try to put the people in their place or try to get the irritation to stop, right? I mean, you've experienced that before, right?
Yep.
Yeah.
I remember the Holy Spirit teaching me, this is what you need to do. If you're having a conflict with someone, first you need to pray, if it is even, I have to pray if it's even His will to even talk to that person. So number one, so if it is His will that I even talk to that person, what does He specifically want me to say to this person? Not only is should I specifically say, how should I say it? Where should I say it? How should I say it? Now, that would seem kind of anal, wouldn't you think? Well, I don't need to do all that. I know what I need to do. But
right, yeah.
From what I've learned from the Gospels, that's not the case. Because even though we think we may do something right that straightens things out, will actually cause more of a problem. And then relying on Him is an act of faith, and obviously trying to talk to people to restore them or to keep the relationship happy. It's not always well received, but you would think that would seem kind of crazy, right? Oh, I gotta rely on the Holy Spirit to actually know what words to actually speak in this situation?
Yeah.
I mean, does that sound crazy to you guys? Or is that?
No. We know right where it comes from.
See, this conversation, look, we went back to the Bible. You see?
Yeah.
Because if the judges knew Jesus Christ, if the police officers knew Jesus Christ, if the legislators knew Jesus Christ, none of this stuff would be going on. If the people knew Jesus Christ, they'd be learning to love one another. and we wouldn't come up with these controversies in the first place.
Yeah, I agree.
Do you see how simple that is? But nobody's doing that.
Nope.
All right?
Well,
Chris's wife gets bent out of shape. She leaves him. So you got this whole controversy. She goes to the dark side. The dark side starts, bringing stuff up. The prosecutor, the state troopers, the judges, they're not interested in reconciliation. They're not interested in being the protectors of the greatest commandment, which is to love. Right?
Yeah. No.
So that's why we have all these problems, and I'm not getting fired. I'm just getting fired up because the answer is so simple. It's just we as sinners just complicate everything because we forget the simplicity of the gospel.
Yeah.
Why'd you pull me over, Mr. Police Officer? Because you're not walking in love. You're walking in and you're being an adversary right now. Why are you arresting me right now? Why are you throwing me in jail? Why are you slapping on the handcuffs? Why are you putting a gun in my face? Now, if you loved me, you wouldn't be doing any of that. We just sit and talk and work the thing out. We've got this whole facade of sin going on that people you just can't comprehend it. No, Judge, you're not loving right now because you're breaking the greatest law. You're breaking the greatest commandment. Who knows? Maybe the Holy Spirit will give someone boldness to say that to a judge or to say that to a police officer. Anyway, I'm starting to go on a tangent. I got to stop.
Well, it seems to work. I mean, what you did and praying for them from the back of the police car seemed to work. I mean, it changed the dynamic.
Yeah.
To the point in my situation that he said before he left, after he booked me in the jail, he said, I appreciate what you're doing.
Yeah.
And when we showed up for 18 months in a row to go to court to work this out, to try to negotiate law, it seemed to be respected by everyone but the prosecutor.
Yeah.
The prosecutor didn't like us at all, but if I didn't bait him, if I hadn't called him SOA, SOA, SOA all the time for months and months.
What's SOA?
Well, they have this.
Name change to state of Alaska to SOA.
Okay.
Was a municipal corporation under USA. Every state was SO whatever. SO. It's just too bad it wasn't SOB.
Easy, Maria.
It was close enough that I could call him SO. If I could have called him SOB for 18 months, I would have loved that. But he understood. He understood the implication, and it was funny. So, but we went in there in good faith to try to help change the system, and they knew.
Yeah.
They knew. We would have done better if it had been more like now. We know a lot more. We could have been more helpful to the system, now. But, and Alphonse he's still going after people. And like Chris is still going after people, and a lot of the guys up here are still going after these quote unquote, whatever word they might want to insert there because they're bad, bad, bad. Well, this, especially right now, we're in a spiritual battle, and that's the best way to fight. It's not kinetic warfare anymore. It's a spirit of forgiveness, a spirit of love, and sharing the message.
Yeah, and it's really shouldn't be about fighting. Again, it should be about It should be about gentle accountability. Like in the scriptures, have you read about the chastisement when the Eternal chastises his own people? Have you read that?
No.
If you read in Proverbs chapter 3, it talks about the Eternal chastising and how we shouldn't think it's something strange or we shouldn't get upset. I'm basically paraphrasing it. It's also in Hebrews chapter 12. Anyway, my point is this. Are you familiar with the word chastisement?
Yeah. Uh-huh.
Now, what do you think of when you hear that word?
I think of being dressed down very much with words, someone really giving you what for, being chastised.
How about a physical punishment?
I don't think of that, but...
That is part of the meaning of the word, but primarily what it means is to be instructed. So
okay.
basically these people need to be chastised. They need to be instructed. They need to be held accountable, not to destroy their lives, not to get revenge, but to instruct them, saying, listen, you've exceeded your the bounds of your delegated authority. This is what the law says. So now we need to come to a meeting of the minds and work this out, along those lines. That's the way I see about trying to learn to go on the offensive. That's where I'm strong. That's where my mind strongly is right now. And you guys heard me say that before. Is not to destroy these people, but just to keep them accountable. And hopefully they come to acknowledge the truth and get saved.
Yeah.
Because that's the only way the system's really going to be not reformed but transformed. And it seems like it's an impossible idealistic philosophy, but nonetheless that's the core of the gospel. That's the way anything's going to be perfected. Without that, forget about it. It's futile. It's just a futile, in my mind, it's just a futile endeavor without him. There's no purpose to it.
Well, and who in the world would have thought to do that, to love and to use do a spiritual battle to show I think of it as love over fear. Because all of these people that are affecting these things, they're compartmentalized, and they're just fueled by fear.
Yeah.
So nobody in the world would have ever thought of that as far as being the prescription for freedom. But yet that's what we were told, and that's what we need to do. And it can take on a lot of forms. When I listen to that Alphonse guy, I hear love. I hear proactive, positive,
No vindictiveness?
No, not really. Not in his voice. He is not afraid to put people in their place. But you got to interpret too. And he also needs instruction. And I'm serious that he probably needs to have your influence. And it's good you're both in Pennsylvania. You know a lot. You've come a long way on this study of yours. So your influence on him could be a very, very good thing.
Well, that would have to be the Lord's doing.
Yeah, well, I'm just expressing, what just an idea. It could work, but yeah, exactly. So I'm not saying an idea. Yeah.
Yeah,
well, I'll send you stuff, and we'll go from here, I guess.
Okay, great. All right, I'll when I edit this recording, I'll send it so you can make it part of the package. All right, guys, enjoy the rest of your day, and I'll talk to you next time.
All right.
Sorry.